All rise. The Butler County Common Pleas Court is now in session. The honor.
Seated. Mr. Burris, did you wish to call the case to order?
Yes, Your Honor. We're here on Sale, Ohio versus John Carter. It's case number CR 2020-23-030345. On the court's docket this afternoon for sentencing. Defendant is present before the court along with all three of his attorneys, Mr. Lawrence Hawkins III, Mr. Christopher Pangan, and Mr. Jacob Long. Ohio. Prosecutor Michael Moser is present. Assistant Prosecuting Attorneys Katie Blackmore and Brad Burris.
Morning, Your Honor. Afternoon.
Good afternoon. Any reason why sentence should not be imposed or anything in mitigation?
No, Your Honor. Your Honor, as we go through this hearing, we're requesting that our client be able to remain seated at defense counsel's table until the sentence is actually going to be presented.
That's fine.
For the record, Lawrence Hawkins III, along with co-counsels Chris Pangan and Jacob Long, here on behalf of our client, Mr. John Carter, for the record is present. We first want to take time to take in consideration, asking the court to consider the sentencing memorandum that was authored and submitted by Chris Pangan, as well as the letters of support that were gathered and submitted by Jacob Long. For the record, all the defense team has reviewed the pre-sentence investigation in preparation for this hearing.
Very good.
Our client will be waiving allocution today. Your Honor, mitigation, and I'll be relatively brief, but it's necessary to highlight a few things that have been gone over already. We want the court to focus on the law. There may be some emotional statements that come out today, and that's understandable. But at the end of the day, our courts make decisions not based on emotions, but based on the law. We want the court to make a decision based on the law today. The Ohio Revised Code 2929-11 states the purposes and principles of sentencing are to protect the public from future crime, to punish the offender, and promote effective rehabilitation. Using minimum sanctions, the court determines accomplish those goals without imposing unnecessary burden on state or local resources. The law requires the court to consider several things. We must first note that the offense for which our client is being sentenced is involuntary manslaughter, not murder, not abuse of a corpse. A sentence should not be harsher based on the original charges, but focused on the charge for which our client has pled. That offense is one that the commission of a misdemeanor was the proximate cause of Katelyn Markham's death, not the commission of a felony. The law says a prison sentence in this case is not mandatory. The law says there is no presumption of prison in this case. The law says that a community control sanction would be appropriate in this case. The law says consider our client has taken accountability, as the prosecutor referred to at the time of the plea. This was a matter of showing accountability. Accountability and responsibility is something that should be considered by the court with regard to this disposition. The law says consider that John Carter has no prior juvenile record. He's never been sentenced to Department of Youth Services. The law says consider that he has no prior felony record. He's never been sentenced to prison. The law says the court should consider the fact that the only record he has is a low-level de minimis misdemeanor from years ago. The law says consider the fact that the 14 days that John Carter was incarcerated on this case is the only time he's ever been incarcerated in his 36 years of life. The law says consider the fact that over his 36 years of life, he's been steadily employed, he's married, and a father of young children, and he's lived a productive life. The law says consider the fact that John has great family support, and a number of people are here today in support of John, filling this place up, and you've heard and seen letters in support of John Carter. They're character references. They're not speaking about the allegations in this case, but they're speaking to the character of this young man. The law says that the court should consider the fact that John has been supervised by this court since March of 2023 on pretrial services. Well over a year. He's been on GPS monitoring, and has had a almost exemplary perfect supervision while that's been going on. The best indicator of how someone's going to conduct themselves is how they conduct themselves while a case is pending. And he's done an excellent job. And that's indicative of how he will do in the future and how he would do if he was given the opportunity to be on community control. The law says the courts should consider the recidivism factors. And I'm not going to go through all those that were in the sentencing memorandum, but when you look at those, they indicate that John is not likely to commit future crimes. The law says the court is to look at factors for the seriousness of the offense. And when you look at those factors, the majority of those predominantly show and evidence that this is not the most serious form of the offense. The law says using the minimum sanctions to accomplish the court's goals so as not to cause unnecessary burden on state and local resources. Community control is a lesser sanction than an incarceration in prison. Fewer resources would be used on that, and you could still accomplish the goals of protecting the public and rehabilitation, as well as punishing the offender. Your Honor, the law says John is amenable to available community control sanctions, and based on the aforementioned information already indicated, that's an appropriate sentence. The law evidences that if the court finds that community control is not appropriate, a minimum prison sentence would be appropriate. The law says furthermore that if a prison sentence is imposed, that a maximum sentence would not be appropriate based on all the factors to be considered. We ask the court to impose a sentence based on law and the sentencing guidelines, the purposes and principles of sentencing, not based on emotion. We ask the court to courageously impose a community control sanction or, in the alternative, a minimum prison sentence. Thank you, Your Honor.
Thank you, Mr. Roth.
Your Honor, we will ask that, as there may be additional individuals that speak coming before you, that anyone that does come to speak address their comments to the court versus any individuals.
The court will indicate, as a matter of record, obviously, that I am the one that is going to be passing this sentence, and it would be most productive for anyone that intends to address the court to address their statements to me, as opposed to anyone else in the courtroom. Furthermore, the court, just so that the record is clear, Mr. Carter, it has been indicated that you do not wish to make a statement. I just want to confirm that that is in fact the case.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
On behalf of the state.
Yes, Your Honor.
Your Honor. There is a favored expression among lawyers that has pointed application to this case and the sentence Your Honor is about to impose. Justice delayed is justice denied. It applies because from the first suggestion by the defendant that Katelyn was, quote, missing until the first report 2 years later that her remains were found, this defendant knew where she was, how she got there, and by his guilty plea, his cause of her death. During each hour and day of that 2-year period, Katelyn's father suffered unimaginable pain and anguish by her disappearance, and as happens in such cases, he had to be ruled out as a suspect in her disappearance and death. From the date of her disappearance until the date Defendant Carter spoke the words to you and the world admitting that he caused her death, he put multiple law enforcement agencies and my office to the test to prove his responsibility and accountability for Katelyn's death and all the suffering he caused. That time and those resources cannot adequately be measured in mere dollars or what he took from Katelyn and all who loved her. His plea put an end to all doubt of his guilt that even a trial would not have accomplished. A successful trial would no doubt lead to seemingly endless appeals and his perpetual claims of innocence lies, and alibi. The plea of guilty ended all that uncertainty with finality. Or has it? The defendant has given the court 29 statements from those who attest to the defendant's good character, but are absent any mention of Katelyn and the defendant's cause of her death. I called one of those personally to inquire and was told the defendant maintains his innocence and only pled guilty to avoid a harsher result than the one he faces today. The defendant thus lied about his innocence. Or did he lie to you concerning his guilt? If he did, we all need to get on with the trial. Everyone should know, however, that the defendant's attorney, Mr. Pagan, submitted a sentencing memorandum in which he acknowledges the truth of the defendant's guilt, and Mr. Pagan is an honorable man. He states, and I quote, "And he concedes," referring to the defendant, "the offense arose from their relationship," his and Katelyn's, end quote. This is the first acknowledgement beyond his admission in court that he caused her death and is absent from the pre-sentence investigation by his choice. It is noteworthy that no discussion of a guilty plea was ever entertained until the defendant's lead attorney approached my team weeks ago seeking a plea of guilty to manslaughter. There was never any suggestion of an Alford plea where a defendant's innocence can be maintained, but with acceptance by a defendant of a conviction to avoid a harsher result, as he claims with one of his character witnesses. The plea offered by defendant Carter was straight out guilty of causing Katelyn's death, a clear and spoken admission and desecration of a corpse that surely occurred by his hand, a delay for which he is responsible, and the injustice of that. The court now has before it the pre-sentence investigation where the defendant was given the opportunity to explain himself, to proceed on the road to redemption with a good act of contrition. Instead, as reported in the pre-sentence, he did neither and gave no account other than his admission to you of his guilt and that he caused her death, with no explanation to solve the mystery of how and why he killed Katelyn. That failure alone is a principal recidivism factor in favor of a maximum sentence, and for all those unanswered questions and all the grief and sorrow he caused, he deserves the maximum sentence available under the law that no one should find just or justice for Katelyn. His ultimate plea surely was not to assuage the pain he caused and garner some benefit of accountability. Defendant Carter had the benefit of 3 skilled attorneys, and with them a risk-benefit analysis of the trial about to take place, and the conclusion a jury would make in the battle between circumstantial evidence and coincidental evidence. After 13 years of unanswered questions and 18 days before his trial would commence, he made an unqualified admission of guilt. All that he deserves now is to serve every day from this day of the maximum sentence I ask you to impose. Thank you, Your Honor.
Thank you so much. I understand that there are members of the family that wish to address the court.
Yes, Your Honor. A couple of other matters. There are approximately 55 victim impact statements I believe the court has received. There is one statement that I believe was signed by 120 individuals. I think there was another victim impact statement that was signed by approximately 150 individuals. I do believe there are 2 individuals that wish to address the court. David Markham, the father of wishes to address the court, and Tina Barrett, who is represented or is representing the Markham family throughout this whole ordeal. So, gentlemen, would like to speak first. I think the court would probably want like one at a time.
Yes, yes, and the court will make clear.
Stand with him as his counsel?
That's fine, that's fine,
I believe the court.
that's fine.
It's on you.
I will make clear as a matter of record that the court has taken the time to read each and every one of the victim impact statements that has been offered. They came in at various times over the past several weeks. The court has also, as indicated before, taken the time to read the letters that were offered in mitigation on Mr. Carter's behalf as well. Mr. Martin.
Your Honor, I could go on and on about how painful. Every Christmas, birthday, the date she was found for the past 13 years. The bizarre phone call I received from John screaming in my ear that Katelyn is missing. The odd 911 call. How I watched John attend searches and visual candlelight services, knowing that he knew exactly what she was doing. Dating her best friend, having children with her, and then marrying her. Yes, the pain and anguish are real. The worst nightmare a parent ever dreams will happen to them. Your child goes missing. That happened to me and lasted nearly 2 years before she was located. And she was located in a pile of trash. The action displayed by John as she was tossed out like garbage. The lack of human respect by John is disgusting and scary. John has no respect for anyone, only looking out for himself. I hope there is no one else next. It is very heartbreaking knowing someone treated your child with such disrespect and the impact it has on your child and her sister. Allie was and is devastated. She wanted to be an aunt, but John Carter took that away from her and proceeded to live his life as if nothing had happened. Not a day goes by that I do not think of Katelyn. She had talent, dreams, and was making a name for herself. She was a bright, bubbly young woman, and it hurts knowing I do not get to see her blossom. See all the wonderful artwork she would have produced. I am so proud of her and looked forward to a wonderful life with my 2 girls. John Carter took that away from me. John has caused so much grief and pain for my family, my friends, the community, and myself. The most recent event happened just a few weeks ago. Allie walked into a Home Depot and John was there with his family. How horrific for Allie to have to see the person who murdered her big sister was there living life. John pled guilty, but was still free. Allie has that fear every time she goes in public that she may run into John Carter. Your Honor, I implore you to sentence John Carter to the maximum allowed by law. I do not feel 3 years is justice. Not for Katelyn, not for her sister, not for me, her friends, and the entire community that has ached and grieved alongside of us. John Carter was not a nice person. The only remorse he has ever shown is when he feared he might face prison. Let him feel the pain that so many of us have endured for the past 13 years. Thank you, Your Honor, for your time and consideration.
Thank you, Mr. Martin.
Your Honor. Tina Barrett on behalf of the Markham family, and I would like to start by reading a statement from Katelyn's sister, Allie Markham. Judge Boyd, my name is Allie Markham, and I'm Katelyn's little sister. I was 15 when my sister went missing. I'm now 28, older than Katelyn ever got to be. Putting my thoughts and feelings into words has proven to be very difficult for me. I have shied away from the media and found it very difficult to open up about the pain I've experienced, even with my friends and family. As I was just entering high school when everything happened, I feel John Carter stole the last years of my childhood and most certainly changed my life forever. For almost 2 years, I had hope that Katelyn was still alive. I wondered where she was and what she could possibly be going through. At 15 years old, I thought about the possibility of my sister being trapped in someone's basement, being tortured, and trying to escape. I had nightly dreams that she would one day come home like nothing happened, and everything would go back to normal. But as we know, that didn't happen. Instead, I watched my parents' lives be shattered. We all tried to navigate holidays, milestones, everyday life without Katelyn. I lived with the guilt that maybe if I had been there that night, this would not have happened. John Carter and his mother actually planted seeds of doubt that it was my fault for not locking the downstairs window, possibly allowing an intruder to get at Katelyn. Only to find out 13 years later, the intruder was him. I watched John Carter hug my dad and try to console him, knowing Katelyn was never coming home because he had killed her. During the search for Katelyn, John lied to me. He reassured me that everything was going to be all right. He told me he was journaling and he planned to share the journal with Katelyn when she returned. He said they were going to laugh together about how people were treating him and accusing him of doing something to her. In that moment, John saw a teenage girl upset because her sister was missing. And he chose to manipulate her to better his own image. He knew he would never be able to share that journal with Katelyn, if there even was a journal, because he had killed her and he had hidden her body. John took so much away from this world when he ended Katelyn's life that night. He stole the sunshine she would bring to any situation. He stole her contagious laugh. He stole her amazing talent. Talent that Katelyn never got to develop. Katelyn had to miss out on so many opportunities because of John's selfish actions. Even if whatever happened that night was an accident, covering it up and lying for 13 years was most certainly not accidental. John has never been concerned for anyone but himself. He has lied, manipulated, and tortured Katelyn's family and true friends for over a decade. John Carter is responsible for killing my sister, dumping her body like trash, and lying to the world for 13 years while he continued to live his life. He is not a victim. I believe the least he deserves is to sit in a cell, alive and uncomfortable, for 3 years. And that is from Katelyn Markham. Your Honor, I have another statement that is prepared on behalf of the Markham family from both a personal and also a third-party perspective that they would like to have shared with the court today. Your Honor, John Carter he treated her death exactly the way he wants you to treat his punishment here today, with a focus on him and his needs. In that he is consistent. He knew she was dead, and instead of allowing her family the ability to grieve for her and bury her and honor her memory by telling them she was gone, he let them suffer and compounded their suffering with the lies he told to keep himself from having to explain what happened that night. If John Carter caused Katelyn's death while committing a misdemeanor crime and therefore is guilty of involuntary manslaughter, as we all know, because he made that plea and this court accepted that plea, then he knew she was dead because he was present when she took her final breath. When he called Dave Markham screaming, "Katelyn is missing," he was lying. When he called 911 and said, "My fiancée is missing and I can't find her anywhere," he was lying. When he spoke to the media and told the story of texting with her that night, sending good morning texts and becoming worried and freaked out because she wasn't responding, he was lying. If Katelyn Markham had actually returned his messages that morning, he would have freaked out because he knew she was not going to bed when he left her that night. He knew she was deceased. For 2 years, he continued to lie while Dave Markham went to bed every night, terrified that his daughter was somewhere suffering and needing him and wondering why he was not there to help her. Katelyn Markham finished out her childhood wondering if she'd ever know what happened to her sister. And the lies did not stop there. John Carter continued his charade of being a victim in this whole thing, pretending not only did he lose the love of his life, but people were being mean to him by suggesting that he had something to do with it. Instead of telling Dave Markham what really happened to his daughter, John Carter went on with his life, had children, bought a house, and got married. And now, 13 years later, John Carter, through able counsel, wants you to consider all that he has done to build a good life as evidence that he is worthy of leniency. The problem is, that's just one view, the view from John Carter's eyes. Everything he's done for the past 13 years has been built upon the suffering of others. Those 13 years are built on lies, deception, and cruelty. His ability to move on was at the cost of Katelyn's family's ability to move on, of not being held hostage, not only by the grief of the loss of the child and their sister, but by not knowing what happened to her. And the continued farce that it was all just a big mystery to John Carter. He has no history of good behavior, unless you count the day he said guilty. But even then, his tears were for himself. He has no remorse for Katelyn Markham or her family. The punishment for this crime carries the potential of 3 years in prison or no prison at all. Because we as a society understand that circumstances matter. Today, we ask this court to consider the circumstances, but not only from the perspective of John Carter. We ask the court consider the view Katelyn's family and friends have had for the past 13 years. That view has been full of deception and disrespect. That view does not call for leniency. There is a range of potential punishments for a reason. John Carter deserves the harshest punishment this court can impose because he has earned every bit of it. Nothing else on behalf of the family, Your Honor.
Thank you, Ms. Barrett.
Thank you.
Nothing else on behalf of the state.
Thank you, Mr. Burris. The court certainly agrees with the assessment that we're obligated to follow the law. I think every court would certainly agree that we are bound to the law as it is set forth. And in this particular case, as with any felony case, there are factors that the court must consider. Of course, in the consideration of those factors, it's not simply a mechanism. It's not a computer that ultimately arrives at what is a just result. It's men and women that serve our communities as judges that have to use their sense and their sensibilities in navigating the way that the law is written to find a result that in some way, shape, or form arrives at justice. And many have said that in this particular case, whatever this court might do won't be just, because the punishment won't possibly serve the interests of making right, or even beginning to make right, the loss of life that was the basis of this case. And certainly from the defendant's perspective, and the many letters in support that champion his cause, that aside from the incident that brings us before the court today, that Mr. Carter has led an otherwise law-abiding life. The court does find, as was indicated during Ms. Barrett's statement, that those assertions have to be taken through a lens of the facts of this particular case. And when the court looks to the sentencing factors that it's obligated to consider, it has to look at it through the lens of this case. To that end, as the defendant states in the sentencing memorandum, it is clear that there are serious physical harm, is the most serious physical harm that the court could possibly consider, the death of the victim. The court also considers that the offender's relationship facilitated the offense, and that was never in question with respect to the relationship that existed and has been acknowledged both in the letters on behalf of the Markham family as well as the letters on behalf of Mr. Carter speak to the nature of this relationship, the loving, caring relationship that existed between these two people. And of course, we see that on all too regular a basis in courts throughout Butler County, the state of Ohio, and everywhere. The domestic violence and the types of acts that take place behind closed doors are tragic. Tragic that they come out of these relationships that are supposed to be built on love and trust, and that's not where they end. The court agrees that Mr. Carter has no criminal history aside from the case that's before the court today. The court does take exception, however, with the assertion that when we talk about the recidivism factors, that none apply to Mr. Carter. The court believes that Mr. Carter has shown no genuine remorse for this offense. And that is exhibited through the fact that if we look at this through the lens of the charge to which he pled guilty, that essentially this was in the eyes of the law, as it would apply to that particular charge, a misdemeanor offense gone horribly wrong with an unintended consequence of the death of a loved one. What is the reaction that a human being would have? It was a shoving match, it was an assaultive behavior, it was some type of a misdemeanor offense with no resulting death intended. When does the call come? Begging for help and assistance. When does the acknowledgement come that this person that I've loved, that I've caused their death, that her family needs to know, that the community needs to know, that they don't need to be constantly in fear that there's some madman on the loose that would break into random apartments and attack anyone and everyone from the city of Fairfield. Ultimately, there was a plea, and there was some degree of responsibility that was accepted by the defendant, but it was calculated. The cost-benefit analysis that the state offers rings true with the court. The lack of any true explanation in the body of the pre-sentence investigation or otherwise, the court finds it disingenuous to believe that there can be genuine remorse without acknowledgement of what took place. Counsel, if you and Mr. Carter would please approach the podium. The court has considered the record and overriding purposes of felony sentencing to protect the public from future crime and to punish the offender and promote the effective rehabilitation of the offender, using the minimum sanctions needed to accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the seriousness and recidivism factors set forth in Ohio Revised Code sections 292911 and 292912. I have considered the information contained in the pre-sentence investigation, as well as the victim impact statements and the mitigation statements that have been offered to the court. I have also considered any and all statements that have been made at this hearing. In light of those considerations, the court imposes the following sentence. The court finds, based upon the serious nature of this offense and the factors that have previously been indicated, that anything short of the maximum sentence would demean the seriousness of the offender's conduct and its impact upon the victim, and therefore will impose a definite term of incarceration of 36 months. There are 14 days of jail time credit to which the defendant is entitled. Being that the court has imposed this sentence, there is also a mandatory period of post-release control of a minimum of 1, not to exceed a maximum of 3 years. If you violate the terms and conditions of post-release control, the parole authority can return you to prison up to 9 months per violation, up to 1/2 of the original sentence. Also, if you commit another felony offense while on post-release control, the sentencing court could sentence you to prison for an additional year or the time remaining on post-release control, whichever is greater, just for committing the new felony offense. That time would not be included in any sentence on the new felony conviction itself. Do you understand that, Mr. Carter?
Yes, Your Honor.
The court has considered your financial resources and your ability to pay financial sanctions both now and in the future. The court will order that you pay court costs. If you fail to pay the costs associated with this case, the possibility exists that you will be ordered to perform community service work and given credit towards the outstanding balance for each hour of community service performed in an amount equal to the then existing amount of minimum wage in the state of Ohio. I note for the record that there was no restitution that was requested in this case, as the court was made aware that funeral expenses were taken care of by a third party. Mr. Carter, you have the right to appeal the sentence in this case. You do that by filing a notice of appeal with the clerk of court for Butler County within 30 days. If you're unable to pay the costs of the appeal, you have a right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, counsel will be appointed without costs. If you're unable to pay the costs for the documents necessary for the appeal, those documents will be provided without costs. If you wish to have a notice of appeal filed on your behalf, you simply need to instruct your current trial counsel to file that, and then ultimately, if it's retained counsel, they'll handle that issue, and if you need counsel appointed, they'll have you fill out an affidavit so that the court can appoint counsel if that becomes appropriate and necessary. Counsel, anything else that you wish to place on record?
No, Your Honor, thank you.
Mr. Carter is ordered remanded to the Butler County Jail pending his transfer to ODRC.
All rise.